Hello and welcome to this ET Now special. I'm Nayan Rai. In a massive development today, the Supreme Court has quashed the RBI's contentious Feb 12th circular. It's being seen as a big impact for power, sugar, shipping companies, with the Supreme Court setting aside that controversial Feb 12th circular, which came out in 2018, instructed defaulting companies to restructure within 180 days or to face insolvency with the trigger of the Insolvency and Bankruptcy Court. While the circular declared unconstitutional, banks and defaulting companies are negotiating individually, and there are bad debts of about 2.24 lakh crore rupees that needs to be resolved under this. These are all cases that are under the NCLT. But a lot of unanswered questions. If there are no 180 days of a deadline, will the NPAs, the promoters and the banks be in a rush? Will we see the banks reverting to underreporting of asset quality? What about all the cases which are already at the NCLT? Is withdrawing them the best solution? What about all the deals that were going to be struck? Nearly $5 billion of deals were going to be struck. And will there be a spillover effect to other NPAs, like, for example, SR Steel, Bhushan Power, or all the other companies that are in the RBI's priority for resolution? Before I start discussing that and inviting you, all my panelists, I want to bring you a very special interview. It's with a present RBI board member, Sachin Chaturvedi. I interviewed him earlier in the day, and this is an RBI board member who concedes the RBI circular never had the blessing of the entire board. It was not unanimous, and it was never a good decision to not allow mechanisms like corporate debt restructuring, strategic debt restructuring, the S4A.
During those stormy RBI board meetings, we had a lot of discussions in terms of the viability of such a circular across the legislative frameworks. And today, the Supreme Court's decision is absolutely clear in terms of how we go forward. Two things here are important. One, that the circular asks companies with borrowings of more than 2,000 crores to have a window of only 180 days to be deferred to NCLT. And second, which I think was absolutely important, was to do away with the extant debt resolution mechanisms like CDR and SDR.
But I also now want to understand, so that what is this going to mean for NPAs, for breaking bad debt, for the cleanup of banks? With this judgment, does it mean that, once again, all the NPAs and the promoters can start relying on instruments and mechanisms like SDR, CDR? Has that come into effect? Would that be your understanding of the judgment? And what is this going to mean for the Insolvency and Bankruptcy Court? Will this now not delay resolution? That 180-day deadline is no longer going to be sacrosanct?
See, there can be no doubt about the fact that you require discipline in the banking sector. The RBI was right in terms of bringing in reforms, and we need to see that at the same time, government has also come up with IBC, and a genuine commitment for bankruptcy reforms is coming up. But we need to also distinguish here and nuance it better whether a generic circular of this nature could have been avoided. So we need to see how now we move forward. There can be no doubt that you require the public sector banks to be insulated from getting into the NPAs and the huge challenge that we have landed up with. But at the same time, we have to give industry the necessary support that requires them to steer through the wider global challenges.
Can you explain to us, because I think there's so much confusion about what's going to happen to resolution. So, while you are in Germany and you're studying various European procedures as well, the Indian situation is, of course, very unique too. What happens? Because, there are also cases of the Insolvency and Bankruptcy Code under Section 29A not allowing related parties and promoters to bid for the assets. Now, with Feb 12th circular gone, is it also a backdoor entry that would be given to promoters, you think? Because insolvency and bankruptcy court can be avoided altogether. And you on the board of RBI, sir, seem to be in favor of that. You seem to be in favor of giving the promoters an opportunity, of giving the companies one more chance.
I'm not saying that. What I'm saying is that let the banks take a call, which would have to be done at the micro level, which a generic circular cannot manage. It has to be done. It has to be tailor-made to specific firms and specific actors because they are the borrowers. So the banks would have onus to ensure that they do not end up with NPAs. But a generic circular would stifle the economic growth that we are expecting, the industrial production expansion that we are looking at. And given the global context, it is all the more pertinent on part of the public sector banks to exercise that caution. And we need not get into that micromanagement through generic circulars. The concerned banks would have to take that call.
Well, there you go. That's the RBI board member, Sachin Chaturvedi, on ET now, exclusively confirming that the entire RBI board was never literally on board for that contentious Feb 12th circular. I'm going to take this forward now and discuss this with my panelists. Let's invite them. Here's Mr. R. Gandhi, the former Deputy Governor at the Reserve Bank of India. I'm being joined also by Senior Counsel Mahesh Agarwal, one of the petitioners, incidentally, in this case. Mr. Alok Dheer, the Managing Partner at Dheer & Dheer Associates, and our in-house expert and consulting editor, Maitri Bushnarmath. Thank you so much for taking the time out and joining us here. This is Nayantara Rai. Mr. Gandhi, I'm going to come to you first for the RBI's perspective. We just had a current RBI board member talking about how the board meeting was stormy, how his decision was forced upon the board. All the board members had never been in agreement. There was perhaps never a good idea to do away with mechanisms like the corporate debt restructuring, the strategic debt restructuring, the S4A. The first question I want to ask you is, would you say there is now a lot of confusion on ground how India is supposed to tackle the NPA problem, the NPA menace, which has been one of the worst legacies that this government had to inherit, and which is why it came out with the Insolvency and Bankruptcy Court? Is this going to weaken the Insolvency and Bankruptcy Court?
Yes, this judgment has put back or set the clock back by several months. Obviously, the authorities, both the Reserve Bank and others involved, including the government, will have to sort out the confusion that has been created because of this judgment. One possibility, still there is, in practice, the banks on their own can have any kind of restructuring that they want, that they can foster by discussions with borrower. So there is no bar on resolution in the absence of this circular. What the Reserve Bank schemes, the earlier CDR or SAAA and those kind of schemes, what they had provided for was a kind of central bank or regulators forbearance in case certain the resolution scheme conforms to certain conditions. That is what all these schemes included, including the February 12th circular. So in the absence of this, it does not mean that resolution process will come to a halt. Banks can continue with their own resolution processes. And in case the borrowers and the lenders come to the conclusion that the resolution is not going to be successful, in that case they can take the company to liquidation. There is no bar on that by this judgment. This judgment has only said that Reserve Bank directed, Reserve Bank mandated liquidation process is ultra vires. So we have to see the distinction between these two clearly.
Okay, now let me go across to Mahesh Agarwal, who is one of the petitioners in this case. Hi Mahesh, this is Nayantara Rai. So would you agree with R. Gandhi that this is not going to impact India tackling bad debt? You know, you were one of the lawyers involved in this case. My first question to you is that what's going to be the immediate impact of this verdict? 75 companies are going to be impacted? We're talking about 2.24 lakh crore rupees of bad debt. What's the way forward? If you don't have that 180 deadline, what kind of resolution are we likely to see, if at all?
See, I think we should not over-expand the impact of the Supreme Court judgment. The challenge was very limited. It was only to the RBI circular which mandated banks to initiate action if consent was not taken within 180 days. Now, the biggest problem with the RBI circular and why it was not functioning is that it had provided that 100% of the lenders should agree to a resolution to prevent a company from going into IBC. Now, as you know, it is impossible to get consent of 100% of lenders in any case. So that was a major challenge. If the RBI had restricted it to 66% or 50%, then a lot of resolutions would have taken place. But having said that, insofar as RBI circular is concerned, it mandated the banks to initiate action. Once that circular goes, under section 7 of the IBC, the banks can take independent action, independent decision, look into case by case study. If they feel that a company can come out of the stress, can resolve its debt, it can do so by an appropriate scheme. If they feel that the company cannot come out of stress, then of course the bank is free to initiate action. The RBI circular does not prevent the volition of the bank or the decision of the bank to initiate action against any particular company if that is required. So I think we should not feel that there is a major impact or we go back several months because of setting aside of the circular. The banks are free to negotiate, have a resolution in the interest of the company, look at the stress in a particular sector, see if situation can be resolved, and if it cannot be resolved, then of course they can go under section 7 and initiate action.
So Mahesh, what you're telling me, that would mean I was wrong and I was confused. That 180-day deadline should not be confused with this. That's under the Insolvency and Bankruptcy Code.
Correct. So far as 180 days deadline was concerned, it was an artificial deadline brought in by RBI. Let us assume the 180 deadline was not there or the RBI circular was not there. What does the bank do? The bank has to resolve every possible debt. If they are able to resolve either under the erstwhile SDR, CDR, S4A or any other mechanism, it should do so. If it doesn't do, it still has a right under section 7 to take action against a company. So it's not that the IBC is derailed. There was no challenge to any provision of IBC. There was no challenge to 29A, no challenge to 12A. None of the provisions of the IBC code were under challenge. So they are not impacted.
Okay, so that's very important clarification that is certainly coming in over there. Alok Dheer, if I could come to you before I go to Maithili, would another way of looking at today's judgment is that maybe the CDR, SDR, S4A are going to make a comeback?
Certainly. According to me, this is a very important judgment that has come, and it has laid down one basic principle. Following 35A of the Banking Regulation Act, the RBI cannot issue generic circulars like this. The circular which was issued was actually, there are 3 or 4 basic issues. One was early reporting of NPAs. The second was timeline of reference to IBC. The third was implementation conditions of a resolution plan. And the fourth was withdrawal of the schemes. Now, all these were part of what was called the resolution of stressed assets, a revised framework. So there was already a pre-existing framework for resolution of stressed assets. This new framework was put in place, and as has been mentioned by Mahesh, there was a 180 days from the reference date, which was 1st of March 18, that if within these 180 days, the resolution cannot be done, and the resolution starts with default of interest to any one of the lenders. As soon as there is a default of interest to any one of the lenders, the company is in distress. If within 180 days by unanimous consent of all the lenders, the resolution doesn't happen, the company has perforce to go under IBC. That was the real impact of this particular circular. Now, the Supreme Court has very clearly said that insofar as the generic circular is concerned, it is set aside. Very importantly, it says consequentially proceedings including IBC are set aside and quashed. So if proceedings under section 7 of the IBC have been filed on the basis of the 12th of February circular, those proceedings will stand quashed, but it does not prevent the bank from evaluating the case and filing a proceeding under Section 7 afresh in any of the cases which are covered by the judgment of the Supreme Court.
But Alok Dheer, I know, I asked you this question, but do you think maybe we are jumping ahead and doing 1 + 1 = 3? Striking down the circular of February 12, 2018 doesn't mean that the RBI will not have to come out with a fresh circular reintroducing CDR, SDR as well as S4A, or am I wrong over there?
Insofar as the withdrawal of the schemes which was a part of the circular, since the circular in its entirety has been struck down, the provision of the circular which says that the CDR, SDR, S4A, etc., all these schemes stand withdrawn, that condition of the circular has gone. Therefore, all of them have sprung back to life. So all the schemes, whether the CDR, S4A, SDR, are now back into the play and can be implemented. Unless, of course, the RBI comes up with another circular, either modifying or issuing a fresh scheme with respect to resolution of stressed assets.
Yeah.
So the cases which were pending will be brought back to life, and if there was an SDR or a CDR or an S4A pending, it can be implemented even now after this judgment.
Okay, I have a question over there, and that is that is this not exactly what the promoters are going to be citing, even if they weren't under February 12th? I'm going to come to that in just a bit, but Maitli, I want to ask you something else. Would you say that, we're seeing a reversal of Raghuram Rajan's legacy? He had tried to attack underreporting of asset quality. With the Feb 12th circular gone, do you fear that banks will restore the practice of underreporting asset quality? Could that once again become a reality? Because this was supposed to be seen as a check on that as well.
Well, Nayantara, the role regarding NPA, the definition of an NPA has not changed at all. The February 12th circular only said that if there's a delay of even 1 day, then the account is treated as a default. But the NPA definition is still 90 days. So that has not made a difference. In fact, the entire mischief really, the bottom of it all is the Feb 12th circular of the Reserve Bank of India. Because what the Supreme Court has done has taken, as is natural when once you go to court, taken a very legalistic view. And they said Section 35AA is only refers to specific cases where the central government gives directions to the Reserve Bank of India, whereas the circular is a very generic one. So they've taken a very legalistic view and struck it down as an ultra virus of Section 35AA essentially, though they've struck down the entire circular. So unfortunately, but for Reserve Bank of India's very, stubborn approach to the entire thing, none of this mess would have been created, because remember, the Allahabad High Court had asked the government to set up a high-level committee with representatives of borrowers, the lenders, the power producers, the RBI, as well as the central government, to try and come up with some kind of a solution. But the RBI under Urjit Patel refused to send any representative to attend any of the meetings. It was so obstinate about it. So had they shown the flexibility at that particular point of time, I think we wouldn't have reached this very sorry impasse where in the process, even though the IBC itself has not been affected, by the Supreme Court saying that all proceedings, that all debtors proceeded against under the IBC only because of this circular, proceedings have been declared non-est. That means it does not exist. This has really set the cat amongst the pigeons, created a great deal of uncertainty. And my only regret is that had the Reserve Bank of India taken a slightly more pragmatic view, a slightly more practical view, maybe none of this would have happened, because you cannot have a one-size-fits-all across the board. And it still does not rule out banks can still proceed under the IBC. It says that ultimately the decision of whether you want to proceed under to the IBC or whether you want to restructure the account must be left to the lender. The Reserve Bank of India, nowhere in the world does the central bank interfere and say you must refer this, you must take this to the IBC. Unfortunately, in here, the Reserve Bank of India took a very theoretical view, and today we are in this sorry mess.
So, Maitli, because you believe that the RBI was obstinate, was not willing to engage. In fact, we had an RBI board member on ET Now admitting that the board meeting had been very stormy. All the members were not in agreement with the Feb 12 circular. It was perhaps never a good idea to do away with mechanisms like SDR, CDR. So, in this case, would it also mean that you are okay with the Supreme Court striking down a circular of the Reserve Bank of India? Because another way of looking at it is it not a case of judicial activism? Should this, is this not the domain of the Reserve Bank, and it really does not belong to the Supreme Court?
With due respect to Mr. Chaturvedi, I wanted to add that I'm a little surprised that he said the circular was discussed. To my understanding, and maybe Mr. Gandhi can corroborate, circulars of the Reserve Bank of India before they are issued are not discussed in the Central Board. Subsequently, when there is such a furor about a circular, it might have been discussed. But the circular itself, the issuance of the circular, no circular before it is issued is discussed with the Central Board. In fact, that is one of the grouses about the Reserve Bank of India Central Board, that has no teeth. In fact, that has been the entire discussion, whether in the case of demonetization or any of the subsequent discussions, that the Central Bank Board does not have too much of a say. Having said that, I think it's unfortunate that the Reserve Bank of India interferes and tells banks what to do, whether it's in terms of the MCLR, whether it's in terms of whom you must refer to and what you must do. And it's also unfortunate when, as a consequence of this, the Supreme Court has to interfere, because these are not matters in which the Supreme Court should interfere, which is why the Supreme Court has taken a purely legalistic view and said that Section 35AA, the interpretation is purely in terms of the legality of Section 35AA and whether the circular issued by the Reserve Bank of India fits in with that. So this is, I'm afraid, the unfortunate situation started by the Reserve Bank of India and then continued by the Supreme Court. This is an event that has taken its come this way. So now
this was also a circular,
and see what best can be done.
This was also a circular that no one had favoured besides the Reserve Bank of India, headed by Urjit Patel. You even had a wing of the government in an unprecedented manner move against the RBI at the Allahabad High Court. Like Maiti reminded the viewers, the RBI was refusing to even take part in the consultations. Mahesh Agarwal, let's talk about the road ahead. Alok Dheer has said that the inference should be that corporate debt restructuring, strategic debt restructuring, S4A is going to make a comeback. Do you agree with that, or do you think the RBI is going to have to clarify that, come out with a new clarification? And if NPAs are allowed to, start bringing out, going down that route, why will existing cases at the NCLT, not under Feb 12th, be impacted? For example, why will a Ruya family, for example, not say, I was anyway trying to resolve with the banks, I was going down that route, so it's not fair for insolvency to be invoked?
Point is concerned, the circular clearly quashed the STR, CDR and the S4A mechanism. Once the circular is quashed in toto, it's held declared as ultra virus and non-est, then obviously all the schemes will revive. Now it is for RBI to further clarify if they need any modification or they want to come out with any other scheme or any policy. But till that happens, the legal interpretation is very clear. Once the policy, this circular goes, all existing schemes will revive. That is so far the first part is concerned. Insofar as the second question is concerned, so far as existing cases are concerned, each case will have to be now examined on its merits. If there is a case which has been filed pursuant to a circular which was similar to the RBI circular issued now, maybe some questions may be raised. But other than that, if any bank has taken a decision on its own volition under Section 7 and filed a case because the bank has decided as a lender to file a case, that will not be impacted. So 99% of the cases which are pending in IBC will not be impacted at all. There are very few cases which were filed pursuant to 12 February 18 circular, which will be straight away quashed, and rest we'll have to see how it goes.
Wind up. Okay, I'm running out of time, so I'm going to give the last question to Mr. Gandhi, and Mr. Gandhi, we'll have to make it very quick. Do you agree that this is exactly the path we are headed down for, where a lot of the cases, bankruptcy cases, will have to be reopened, will have to be reviewed? The promoters will certainly have a new legal argument at the NCLT.
See, it is not that all the cases are impacted, as just now the other speaker has also mentioned, that there are several cases which were initiated by the banks on their own volition. They are not impacted by this. That is number one. Number two, whether the earlier schemes have been revived or not. Yes, technically they have, those schemes have got revived, but the Reserve Bank will be free to clarify whether that is so, or prospectively it can again withdraw those circulars. The Reserve Bank should be deliberating on that, or Reserve Bank can go to Supreme Court and get a review of the order, saying that certain parts of the February 12 circular is, of course, will stand withdrawn, but the other ones which are not actually out of that section 35AA, those provisions should continue. It can go to Supreme Court and ask for such clarification. These things are certainly feasible.
Okay. So let's see if the Reserve Bank makes those important clarifications. A lot of clarity has come in after this panel discussion. Unfortunately, we're completely out of time. I'd like to thank all four of you for taking the time out and joining us here on this ET Now special.